No one lays down the law like Car and Key. This is the Law Report on SAFM.
Well, welcome to this week's edition of the Law Report program. It's our monthly phone-in, our monthly law clinic this evening, and I'm joined by attorney Nicolene Skuman-Low as well as associate attorney Anya Janssen van Rensburg. And as you know, once a month we do a law clinic. It takes all those questions that don't normally fit into the other topics that we do here on a weekly basis. So if you have any questions, you can call us on 0892 10 2010, 0892 10 2010. We do have a couple of emails to get through, and then we'll get to the calls. But in the meantime, Nicolene and Anya, thank you very much indeed for joining me this evening.
Thank you for having us.
Yeah, thank you.
Welcome. Right. So we should start on the emails, and you've split them up amongst you. So you're each going to do some of them. So we'll start off with the first one. It says, I would like to inquire if you could advise me who we could contact for a Hindu divorce. However, it regards a trust. My mom is not married in civil law. However, she has cohabited for 32 years. Now she needs to obtain maintenance for herself and needs to speak with a divorce lawyer specializing in Hindu marriage coupled with trusts. And then this evening I picked up a follow-on email to that with a little bit more information. It says, my mom has 4 children from the Hindu marriage, but the Hindu marriage was never solemnized formally, so she has no standing. All 4 children still stay at home. My mom has never worked and has been dependent on my dad's support for the duration of the marriage. She still resides there. Our dad is a beneficiary in his dad's, in other words, our grandfather's trust. However, it seems nothing is in his name, but we suspect aspects of the trust were run like a sham. My mom is looking for maintenance or a house if we can prove the trust was a sham. It all sounds a bit complicated here.
Quite. I think the first step would be to contact the local law society for a contact in regards to who specializes in this field of law within the area that the listener is normally resident. And of course, then to start unpacking each aspect, the aspect regarding the trust, on what basis they feel that it may have been run like a sham, and to see where that takes us. And then, of course, to bring the necessary applications once you can prove that. Now, importantly, what I want to mention, if you can prove that the trust has been run like a sham, or that the beneficiaries or the trustees have been treating the trust funds as if it's their own, is it can actually dissolve the trust in totality and then divide it between whoever is the claimant as well as the beneficiary. So it's got some serious repercussions if you can actually prove the sham aspect thereof. So it's very important to get in touch with someone that is not only acquainted to Hindu law specifically, but also the law of trust. As for the maintenance, I assume all the children have reached the age of majority. So regardless of how you are or not married, the biological link between a parent and a child automatically creates the maintenance aspect towards children. So if any of those children were still financially dependent, maybe disabled in some way or form, then they could still potentially claim against the father or against the parent of the father for maintenance. But of course, that hasn't really been mentioned here. So first point of call, I would say, is to contact the local law society and find out who's an expert in both Hindu law and then, of course, the aspects of trust.
So this could be quite a long road then.
Quite a long road. I would say prepare yourself for quite a number of years.
But get started now.
And make sure that it's someone who specializes in the field. It is
and the
quite
law society of wherever they are would be able to assist. I have no idea actually where they live. So if the listener would like to let me know, I can always let you have a listener. If you'd like to just email me and tell me exactly where you are, I can find the closest law society to you and send you those contact details. Right. The next one is from Sandile. He says, I attended a course at a particular college in 2014. The exam is conducted over 3 weeks, where if a student fails a component on week 1, he or she then goes to week 2 to redo that particular component. If a student fails 2 components in week 1, he or she then goes to week 3 to redo all the components. I failed 1 component in week 1 on which my intention to appeal is based. The college does offer students the opportunity to appeal, but this does not prevent the exams from continuing. Appeals are only attended to after week 3. My question is, can I lodge an appeal of the results even though a year has passed? And if yes, how do I go about doing that?
Well, this was quite an interesting one for me. Firstly, I think we need to distinguish between 2 processes, one being the process of a remark and the other being an appeal process, as we as attorneys understand an appeal process. So a remark is essentially if you don't agree with the result that you received in the particular exam, and you feel maybe someone has made a mistake in the marking of that paper. So then that would be the correct process to follow. Each institution has their own procedure in terms of which you can get remarks done, and the costings of that, and some even pay for it if you can prove that if your remark result is better than the previous result. So I think we need to distinguish between remarks, which institutions quite widely apply, versus an appeal process. An appeal process is an internal process where if you do not agree with the outcome of a decision, then you can follow the process and you can get the decision overturned. It's a principle that is applied in our courts as well. So in order to answer the question as in regards to the appeal, we'll actually have to look at the rules relating to this particular institution and to answer the question to see whether or not the process is still possible. By a rule of thumb, though, I can say that appeals usually have a very short or time span within which you can bring an appeal. It's anything depending on the institution from 7 to 21 working days. So a year down the line, I do think that it's maybe a bit of a stretch.
Because he does say here that appeals are only attended to after week 3. So
yes.
He failed this in week 1, and then he would have possibly had to redo it in week 2, but he doesn't seem to think he failed this thing in week 1. So,
yes.
It all just was almost like a snowball effect.
Yes.
And never quite got there. And then everything happened, and now a year has passed.
Yeah. No, I think one also needs to look at why wasn't, and maybe this is something the college can raise. As a defense, if, let's say, an appeal was still possible, why didn't you go for a remark if you thought we made a mistake? Or at least take the second opportunity as a fail-safe to safeguard yourself from having to redo or repeat this year.
Yes.
So it's really, I think there may be quite a few problems here, but rather go to see an attorney, take the rules of the college with you, and let them advise you whether or not it's possible and whether or not procedure was followed by the listener themselves. I mean, that's...
Or maybe just initially just take a look at the rules yourself,
yes.
and just see what they say about
Yes,
appeals.
of course.
If there's a time frame for that.
Of course. Usually there is, with any appeal that we are involved in, there's usually a very tight timeline to prevent matters from stretching out over years and years.
Right, well, the next email is from Renu, who says, in terms of a will, 3 adult children should inherit from the mother's estate. 1 adult son is deceased before the mother. This deceased son has an adult son himself, and when the mother passes, will the deceased son's son, being obviously the grandson, inherit from the grandmother's estate, although the will does not state anything about stirpees? I think first of all explain stirpees, and then let's get on to the question so people understand what that is.
Stirpees is often something that even when we draft wills, we make mention of in our wills. In other words, it's a Latin word that translates roughly into English as by representation. So in the case of someone predeceasing someone else who dies, in this case the mother who passes away, then that person who should have inherited the child, in other words, that was mentioned in the will, can be represented by their child in turn, so that the effect of the will is still carried through. And it's a common principle in our law that within the bloodline, you can represent regardless of what the will states.
Even if it doesn't say anything about the representation thing or the stirpees, whatever, they still can do that.
We prefer, for legal certainty, when we draft wills, to mention it nonetheless. I realize it may be a little superfluous, but we prefer to just mention it so that there's absolute clarity, and these type of questions don't really arise in that case. But the law does make provision that if you're related by blood, so unfortunately,
or by adoption.
Yes. So no stepchildren. You can represent the deceased parent if you are to inherit from your grandparents.
So in other words, in this case, the grandson would be possible to inherit.
And all that they'll do if the master
share, basically,
yes, and if the master disputes this, then of course they can seek legal recourse.
Okay, but legally the grandson should be able to
Yes.
inherit because
Yes.
it is a blood
And
relative.
of course, there's one exception, one big exception. You know, if this person caused the death of the deceased,
Oh, you can't
then
profit from that. Yes,
then
okay.
of course, or if you've signed as a witness on this will
Yes.
as the grandchild, then you've signed your inheritance away. So small things like that, but that's not mentioned in here. So let's not go.
Just to give people that
digging.
word of advice here, if you are mentioned in the will, don't sign as a witness.
Yes.
Because then you can't
Very
get
important.
anything.
Or if you do, then have an additional person that's unrelated and not mentioned in the will sign as an additional witness.
Okay, but normally you need 2 witnesses,
You need
don't
2,
you?
but if you are mentioned in the will, you need another one.
So you need 3 altogether.
Cancel
Oh,
out the
gosh.
bad effect.
Oh my goodness.
So
So rather
rather
just
just-
don't sign. If you mentioned in the will, don't sign it.
And simultaneously, husbands or wives of those witnesses as well.
Yes.
Oh, really?
I also don't know that.
Okay, so if, just for example, I was mentioned in a will and my husband signs as a witness, I still can't inherit.
Then there may be a challenge. Of course, then you'll have to go and show good faith at court and so on and
Oh,
so
right,
forth.
okay.
It can even invalidate the will in totality, which means it becomes intestate. So
Luckily, I haven't done that
it's
thing, so that's
really
fine. I'm fine.
make sure that you get it done professionally. We go back to the beginning and make sure that it even carries through, that whoever's helping you with your will, that they actually help you with the signature thereof. It sounds a little silly, but
Rather just be. We've had enough questions on this show to know that this doesn't always happen.
exactly.
Which is why we have National Wills Week every year.
Exactly. And
Right.
it's coming up later this
It's coming
year.
up. We're going to do it again, and then we can all go off. Those who haven't had their wills done can go off and get them. We've just got a few more emails to get through, so if you want to call through in the meantime and leave your name and number, it's 0892 10 20 10. 0892 10 2010. Now, I'm a bit concerned about the next email because this listener didn't want us to do this on the radio. He wanted us to email him personally. Now, we don't do that, unfortunately. We don't give legal advice over emails and all that sort of thing. I have emailed him twice to tell him that that was the case and to ask whether it was possible that we did this email without mentioning his name. I haven't had any reply to my emails to him at all. So we will mention this, but with no names, and hopefully that will suffice and that the listener is listening. It's a male, is 58 years old, happily married, 3 children. 4th one is a daughter out of wedlock. First daughter graduated with honours degree last year. Second daughter is doing her 3rd degree at university. The last boy is completing matric. And the 4th daughter is doing 2nd year after a long struggle. She's 30 years old. The listener's been on disability for 8 years. He opted to start businesses rather than being idle at home. Started a number of businesses. He also owns some residential properties, of which one is rented out. He's also involved in a partnership with a friend, and there's a whole lot of other business structures that have been developed with that as well. And they're doing pretty well. And we decided to retire in 2018 in all forms of business and start enjoying the fruits of our labor. We've started many businesses that they want to pursue. I'm not quite sure here. They want to pursue their own careers. I'm assuming the children don't want to get involved in the businesses.
I also assume, yes.
And we're contemplating selling all the businesses when we retire. All businesses are individual entities, and both of us are shareholders except in a partnership with a friend. Should one of us pass on, or worst case scenario, both of us simultaneously, how to structure our wills? I've got troublesome family members. That always seems to be a problem. And I don't want them to bother my wife in my absentia. Hence, we want to sell in 2018. So what do you do? How do you structure those wills if, heaven forbid, both of them die simultaneously, or if he dies and then the wife is left with the supposedly troublesome family members? What do you do?
Well, there's a number of ways in which you can handle this. You can keep it simple and say, if something is to happen to me, then, in other words, if I were to pass on, then you need to market and sell my business. The cash that is yielded from that is to go to my wife, or to be divided between my wife and my children equally, or whatever really that you would like to happen to that. Alternatively, there are a number of insurance structures that you can use quite effectively, particularly in the case where possibly both you and your spouse were to pass in the same unfortunate car accident or incident. Then you could insure, the business could insure your life, and that could then serve as the cash money to buy you out in the absence of someone being able to market and sell the business. And that would then still yield the cash. It wouldn't burden anyone. It would be a much quicker wrap-up of things than to go to the open market, particularly in our current economic climate. So insurance provisions, key person policies, life insurance policies that would facilitate the buyout and making into cash other than going to the open market would be a much more seamless way to deal with it. Of course, the health of the listener may be a concern from an insurance perspective. So maybe putting a contingency plan in place, a business continuity plan in place already now is a good idea. In other words, scout someone that maybe one of the employees in one of these businesses that would like to take it over. Start grooming them for that. I mean, two and a bit years is quite a long time. And you can achieve quite a bit if you are focused in that space in time. So maybe that is a third alternative to look at, to say that person is the person I've selected to take over from me. They'll buy the business out over a period of time. So it can be sort of like a pension, whether you are alive or at your passing. So there are a number of ways to structure it. It can be as simple as something happens, you go to the market, hope for the best and sell it for the highest price you can get. Given the climate that we're currently in, that may be quite challenging. Or you can look at insurance policies that would buy you out and put cash in pocket, and then whoever is left behind in the business can go on, and they don't have to sell it and break it up piece by piece, which can be quite a long process, an expensive process.
Now, this would be something I would imagine that you'd go to a professional to help you do this. You really couldn't get this all in place by yourself.
No, absolutely not. So the CNA version of a last will and testament is
not gonna help you,
absolutely not going to help you here. Not that it would if you didn't have a business, in my opinion. But it's really something that you need to think of very carefully. And for many people who own businesses, you need to think of, what is my legacy? If something is to happen to me, what is left over? What footprint have I made on the world? If that's not important, then fine. But structure it in the way that you would make it as easy as possible for those left behind. And besides looking at death, you also need to look at what happens if you don't pass on, but you become severely ill before your 2018 deadline. So insurance is a really crucial point, I think, to examine and to find what fits and to draft the will accordingly.
And there are attorneys that deal with this kind of business structuring and that sort of thing. So
that's something we specialize in and love doing. So,
but you need to find one that does that wherever he lives.
One in the area, yes. That would be best.
Specializes in that, in business structuring and that
business
sort of
structuring, continuity planning, succession planning, as they refer to it in the big corporates.
Okay, so the listener needs to find that out, and then we sort it.
And yes, just one last thing that I would like to mention. The listener really needs to think practically. Where are my passwords? Where are the keys? Those kind of things. When you own a business, you must remember it's as bad for your family that is left over to go through your personal belongings and to find these crucial aspects. But in a business, it's even worse because, yes, you see your colleagues every day, but do we share where you put your passwords and how you do this and how you file that? Most of us just get on with our daily business, really, and we don't do that. So that's really where succession planning has more than one aspect to it: the practical, the legal, and then of course the legacy part that you need to structure.
So lots to do there.
Lots to do.
Right. Next question. I would like to know. We are 10 children. 9 of us have already left my mother's house, and my youngest brother is staying with my mother in the house. Then my mother decided to register the house in his name, obviously in the younger brother, and excuse me, after 1 year, he decided to get married and he bought a house of his own and moved to the new house. So my mother wants him to register the house again in her name, but he doesn't want to do that. So as a family, how can we help my mother to get the house registered again in her name? And is it possible that my mother can make out a will this time around? So obviously the mother made the house into the son's name. The son got married, bought his own house. So he's got his house and the other house his mother put in his name, and now the mother wants it back, but he doesn't want to give it back. How can she make him give it back, or can she make him give it back?
Unfortunately, if the transfer of the house took place knowingly and willingly, there's nothing much that she can do to get the house back into her name. The only possibility would be, and this is a bit of a far-fetched situation, if there was something underlyingly wrong with the transfer of the house, meaning there was some undue influence between the mom and the son or anything like that. but I don't see anything mentioned here. It seems like she knew what she was doing. And in that case, there's not much one can do to transfer the house back into her name.
Unless she willingly wants to do it. Now.
Unless,
or
you
he
know,
willingly wants to do it.
There's 8 other children left. Perhaps, you know, they are able to financially assist her, and maybe if they make an offer to the son, he would maybe be willing to sell it back to her.
But by the sounds of it, she just gave it to him. So, you know, it's...
Well, yeah, it's a difficult situation.
So unless he coerced her or forced her or whatever to give him the house or to put the house in his name, she doesn't really have too much of a leg to stand on here.
Unfortunately.
And the last thing it says, is it possible that my mother can make out a will this time around?
I'm not, well, a will, like you say. Obviously, go and get a will immediately.
You sound like Nicolene. She's absolutely fanatical about wills.
There's nothing preventing it. I'm not sure if they're insisting that somehow in the will she should, you know, let the sons inherit or other children inherit the house. Unfortunately, you can only, you know, leave loved ones assets that you actually own. She could leave the house, but if at the time of her death the house is not in her name, unfortunately the executor won't be able to you know, pass on the house to whoever she's left it to.
So they need to really try and convince the brother to put it back into the mother's name, seeing as he does have his own house now. He's married with his own house, you know, and this really was his mother's house to start with.
Yes, so I guess they'll have to have
a little bit of a family meeting. There's 10 of them,
meeting,
so yeah, there's 10 of them. I'm sure
let democracy rule.
The other 9, I'm sure, would be able to help. Okay, right. Jody sent us 2 questions. The first one says, a person who passed away 5 years ago, can his estate still be wound up when a will could not be found? And can an executor still be nominated? Remember, the road accident fund already started paying out to the surviving spouse, but not to those who were minors at the time.
Well, essentially, there's nothing in terms of law that prevents you from registering a estate. The Administration of Estates Act says you need to report an estate 14 days after the person has passed away, but in practice that normally never happens 14 days after which. But there's nothing preventing you from going to the master and reporting it 5 years along the line. I just think in practice it's going to be very hard to administer this estate now.
Because they said the will couldn't be found. And so that's obviously why nothing moved.
And now, obviously, interstate succession will have to take its course, which will dictate that the master will make a nomination regarding who will be appointed up as executors.
So that can still happen.
Yes.
And then he also says the road accident fund started paying out to the surviving spouse, but not to those who were minors at the time.
In this instance, one should remember that you've got 2 different aspects here. If I'm making probably assumption, but if the person passed away in a motor vehicle accident, the surviving spouse obviously has a claim, if the person who passed away was the breadwinner, to go to the road accident fund and claim for maintenance. Now, any payment the road accident fund makes does not fall into the deceased's estate. That gets paid over directly to the surviving spouse. And simultaneously with minors unfortunately can't act on their own. They can't go to the road accident funds and say, I want to make a claim because my dad passed away.
So the mother should have claimed on their behalf then?
Yes, the mom should claim on their behalf.
Okay, so because the way he says it here, it's almost as if he was expecting them to say, well, there's the mother and then there's these kids, and so we need to pay all of them, but it doesn't work like that. You've actually got to go and say, excuse me, but there are minors here that you also need to pay.
So it depends. It varies. A lot of times, we don't know if the road accident fund obviously started paying out. We don't know if it's a settlement reached out of court or in court. A lot of times, if it was in court, the court would say, well, no payment will be made to the minors until they are 18 for reasons so that it doesn't get abused or anything like that. And sometimes it does get paid out to the mom I'm saying the mom, the parent, the guardian, so that they can distribute it and take care of the children simultaneously. What is probably important to note, if there was no claim made on behalf of the minors, then they still have time to go and claim. Mom can claim on their behalf, and they can, when they turn 18, go to Road Accident Fund and claim. That claim doesn't prescribe because prescription doesn't run against minors. So that's important to maybe note. We're not sure what the settlement was with Road Accident Fund. If she did, I'm presuming it's mom, if the guardian did claim on behalf of the minors or not, but that would clarify the situation. And
So these children can still
yes, and
put
it's
forward
got
a
nothing
claim.
to do with the master of the High Court.
Okay.
It's not something that's going to fall in terms of the estate. The estate can essentially only claim for funeral costs, which we don't know if that was done or not.
Okay.
I presume not, and now it's 5 years along the line, you probably won't be able to claim from the Road Accident Fund for that anymore.
Okay, right. And then Jody had a second question. He says, can a paralegal assist people to draft a will and on completion send the testator and the two witnesses to a commissioner of oaths together, obviously, for the certification if the paralegal is not a commissioner of oaths?
Well, I think that the first point that we have to make is that paralegals are not people that hold a legal qualification in terms of a law degree. They do usually have a diploma qualification and often offer great support within legal firms to the attorneys specifically. So it's really a case of just recognizing the function of the paralegal within the fraternity, and generally speaking, they assist in the drafting, but they don't draft themselves. They should also not be giving legal advice, because of obviously if poor advice is given and the client is dissatisfied, then they can't necessarily report the practitioner, the paralegal, to the law society. They can, however, report the firm to the law society and say a paralegal who wasn't qualified was allowed to give me legal advice. So, of course, there may be disciplinary steps taken against the law firm, but the paralegal themselves isn't an attorney holding a Fidelity Fund certificate, so you can't act against them if something were to go wrong. Similar really to using a builder that is not registered with all the authorities. If something goes wrong, you have very little recourse unless you issue a process in a civil court, and often against someone that doesn't have very much to compensate. As for the signing of the witnesses and commissioner and so on, a commissioner of oaths is only used to co-sign wills when someone makes a mark. In other words, when you maybe your health condition doesn't allow you to produce a full signature on a will anymore, or you're quite old and you can't produce your signature anymore, or you're afraid that it may be challenged as unauthentic, then you'll sign your will in front of a commissioner of oaths. And no, paralegals are not commissioner of oaths as attorneys are, and attorneys are also not supposed to commission affidavits and documents for people.
But you don't need. I mean, you don't need to actually have a commissioner of oaths witness the signatures.
No, not as a default.
As long as the three of you.
If you've made a mark, some people make a cross.
Yeah.
Maybe if you're illiterate, or as I said, there's a disability or a health issue.
But in normal events, if it's just the person who's making the will plus the two witnesses all sign it together in front of each other.
Yes, and if they are of sound mind and they're over the age of 14 years old,
Doesn't
there's no
have to
need
be
for
a
a commissioner.
Okay.
But no, paralegals are not commissioner of oaths. Unlike there are many people that could be commissioners of oaths, accountants and so forth included in the list, but unfortunately not the paralegal.
Okay, last email. Right, then we have some calls. If you want to call in and leave your name and number, 0892 10 2010. Last email, it says, I am the only child and sole heir of my late father's estate, and I hereby request that the legal expert on the show assists me with tracing the title deed of the bond that was taken at a specific bank by my late father. And obviously we can't do that. My father passed on in December 2010, and subsequently his balance to the bond was paid up by the insurance. He obviously ceded a bond, an insurance policy to the bond. The current lawyer, through his legal assistant responsible for winding up of the estate, says this bond cannot be traced. They indicated that all communications with the previous lawyer, who was dismissed as per Master of Court recommendation in June 2012, has brought no light into the matter. According to the lawyer in charge of the file, this is the reason that has delayed the finalization of the estate. I inquired at the bank and could not be given direct answers, nor the responsible person. I subsequently inquired at the Free State Deeds Office and was told that no deed in the property of my father's bond is registered with them. What do you do? I mean, obviously she's inheriting this estate, this house, obviously, but now they can't seem to find the deed or the bond or the anything.
I would firstly make sure that she's done inquiries at the correct deeds office. One should understand that property registered in Cape Town, the Johannesburg deeds office won't be able to assist you, and simultaneously with the Free State deeds office, she just needs to ensure that wherever the property is registered, that she's done, been to the correct deeds office. And I would say 9 out of 10 times, if they can't trace a bond on a property, there is no bond. While reading the question, I was wondering if, in fact, the insurance did not actually pay off the bond.
Well, I would have imagined, because she says that the balance on the bond was paid up by the insurance.
So essentially what would happen is that the bond would be cancelled. So the property would be bond free. And maybe this is where there's a bit of communication gap between the previous attorney and the current one, that maybe the insurance company just took quite a long time to pay out, needed to ensure that the person is in fact deceased and all of those things, and that all the documentation was in order for them to pay off the bond. And this has probably taken a long time, and now the current lawyer had to take over from somebody else, and maybe there's a bit of a discrepancy, they're not really sure what's going on. My advice for her would actually to contact the lawyer, go and arrange a consultation with him, and sit down and discuss what exactly is going on. And he needs to be open to him or to her about what's going on in the person's estate, because
they surely would have then wanted to send somebody the title deed. I mean, that
exactly,
and charge you for it. I know, because they just did that to us. They charge you to send you your own title deed back. The bank does, or the lawyer does that deals with the bank. So they would have, if this bond is paid up, I'm assuming they would have then wanted to return the title deed. So they must have wanted to send it somewhere.
Yes, and
yet the bank knows nothing, apparently.
Well, I don't think the bank would not necessarily be the first.
But they would know that they sent the title deed back, surely. At least.
We've often seen with old deeds, with old mortgages. I mean, mortgages dating back to before the banks organized themselves into the current Big Four. Those bonds are often missing, untraceable, or lost in terms of the original bond paperwork. But you can still find it quite easily in a deed search. Also, when I read this email, I was perplexed how, we've got electronic facilities to search
Absolutely.
the deeds office all over the country. And even if we can just get a reference number, then we can go to the bank and say, listen, this is your reference number. And it does unfortunately happen that the banks do misplace the original bond papers, but it doesn't seem like it seems like a massive communication gap.
So her next port of call is to go back to the new attorney.
Well, yes, he's getting a fee for administering the estate, and I think as the heir of the estate,
Administer it now already.
Yes, that she needs to maybe just sit down, and he needs to explain to her maybe what's going on exactly.
And they need to trace this. As she said, she went to the Free State Deeds Office and was told that no deed was there and her father's bond was registered with them. So as you said, it could have been registered somewhere else. And now you say electronically they can search the whole country?
Yes.
Well, and I mean, this is a 2010 2010 bond. So, I mean, we're not talking about a 1984 bond. And those the early 80s and before, those are often the ones that you can't find, because when the old banks merged with one another, some of them, they didn't all go to one place. Yes. So some went to this bank and some went to that bank. So it becomes like looking for a bit of a needle in a haystack. But even if your bond gets cancelled, if you do a search on the person's full name and their ID number, the whole history of whatever you've ever registered in the deeds office comes up forever.
So this attorney should know that, surely.
Yes, sure.
It's
definitely
something.
Well, this listener should go there and tell the attorney that he should know this and that he could actually check it for her.
Yes. And if this attorney is not a conveyancer, I mean, this is a conveyancing matter, then let him contact a colleague who is, and I'm sure they can.
And all she needs is the father's name and ID number.
Yes.
And that's all she needs, and they can
It
check.
sounds from
It's a communication issue.
from writing that the Free State Deeds Office did actually it sounds like they did trace the property and that there was no bond registered. That means obviously then there is no bond.
It's been paid up.
Or it never has been. There's no current bond. Now you're talking to two attorneys. Is there no current bond, or was there never a bond to start with?
No, but there was. The bond was paid up and from the insurance that he ceded to the bond. So there was a bond.
So then they need to have that bond number, and then once you have a copy of that, because the deeds office scans everything electronically these days, and they have been for a number of years, then you can find all the other finer details, being the bank account number, if you want that. I mean, if the account has been fully settled, why would you want to dig that type of information?
But it is all available, is the point.
But you have to, as the executor, you have to, even if the bond has been satisfied by way of insurance, you have to show it in your liquidation and distribution account. So we come back to what Anya has mentioned. The attorney's getting a fee to do this, and he needs to earn his fee, quite simply put.
Okay. So there are a few things that you can do. Right, let's go to some calls. Teresa in Cape Town, good evening.
Good evening, Corin. Good evening, Nicolene.
Hello.
Hi.
Nicolene, I just want to find out. My parents died respectively 2001 and 2008. 2001 and 2008. We don't have an executor yet. The initial executor was taken off, and we are to nominate a new executor. Okay, so we are 4 heirs. The other 2 then nominated the one heir, the one brother, the second eldest. Okay, I declined. I wrote an email to the master's office. I declined for that executor, for the brother to be an executor. The master now gave me an ultimatum, and he sent me an email this afternoon after several of my emails and my phone calls to them, saying that, I suggest, I don't have a radio on, so I don't know why I get an echo. I suggest that, we see an independent attorney, and then, of course, try and get the attorney also to take up the position as an executor. I got an email this afternoon from the master's office to say that they are actually going with the other 3 heirs, or the other 2 heirs who have nominated the one heir, the one out of the 3. What about my nomination? Does that not count? Am I not entitled to consent?
Well, thank you for
or to decline, which I have.
Yes. Now, of course, you've got a right to endorse or to decline, which you've quite clearly exercised. The master prefers, from my experience, that all the heirs are in favor of a specific person that gets nominated. But of course, if something has been dragging on for many, many years, the master may use their discretion, which the Act does allow them to do, and to then go with the majority on the appointment. If you wish to challenge it, then of course your only forum would be to go to court and then to show good reasons why this person shouldn't be appointed. And maybe it's because they can't really operate with financials in a responsible way, or they don't have any experience, or there's something in their past that opens up a risk for fraud or for misappropriation or for not handling the matter in the honest way that you should. So if you can prove any of that, then of course go and seek legal counsel and take the matter further in a forum. But your only forum would then be the High Court.
Okay, fine. All right. Thank you so much, Nicolene.
Thanks, Teresa.
Good luck.
Have a good evening.
Thanks. Good night to you. Bye-bye.
Bye-bye.
Right, we're off to Bloemfontein now with Sean, who's got a question about an inheritance in Zimbabwe. Sean, good evening.
Hi, good evening, guys.
Hi, is this going to be a complicated story, Sean? It sounds like it already.
My dad passed away quite a while ago, and there's 4 beneficiaries, all children, and I just want to know, when the money gets paid out in Zimbabwe, it'll be in US dollars. Then how do I get the money into South Africa using the will through the Reserve Bank?
Oh, goodness. Well, firstly, it will depend on a number of factors. You'll have to ensure that you've got, or your father, if I heard correctly, had a will in both in Zimbabwe as well as in South Africa.
No, only Zimbabwe.
Only in Zimbabwe. So then you'll just use Forex to get the money into the country. You'll contact a Forex company. They deal with all the Reserve Bank permissions. Their fees are usually much better than some of the bigger financial institutions and the banks. So
Okay.
I would go that route. Unfortunately, if he only had a South African will, South African law is quite clear that a South African executor cannot operate or handle foreign assets, which this would classify as. So there's no way really from a South African legal perspective to use the will in order to get the money into the country through the Reserve Bank. You'll have to go through a Forex agent, which can then get the money in and fill in all the forms and the paperwork.
To a Forex agent, eh?
Yeah. Forex agent is your best call. I wouldn't recommend the banks or a similar large institution purely from a cost perspective.
Okay, great.
These Forex guys, just make sure it's a reputable company.
Okay.
Good luck,
Thank you very much.
All right.
Thanks, Sean.
Okay.
Thanks.
Cheers,
Good
guys.
night. Bye-bye.
Bye.
I thought that was going to be a whole complicated story, and it was actually quite a simple story after all of that. Right, Louise in Johannesburg, good evening.
Good evening to you.
How can we help you, Louise?
I have a rather serious question. My son worked on a jet ski. It's a big object, a very heavy object. He
Okay.
repaired the thing, and unfortunately it fell on his back. His back, neck, and head suffered excruciating pain. I'm just putting the whole big oak tree into a little acorn now. He was in a very bad state. And a friend took him to a friend asked the paramedics to come. They stabilized him and took him to a state hospital. Unfortunately, a few hours later, I think 4 or 5 hours later, the same friend went back to the hospital to find out what was happening. And when he got there, he found that he was still lying there where the paramedics left him. So we asked the nurses and the sisters, whoever they were, what's happening? They said, no, there was no bed for him for the next few weeks. He must be taken back. So in that state, he was taken back. And sometime later, he came to me, and I went with him. The two of us then went to another state hospital, the trauma unit. We spent 4 days in and out of hospital in excruciating pain. Sorry. All they could give him was one after the other painkiller, and he lived on that. It alleviated the pain a little bit, but not the continuous pain. He suffered immensely. Eventually he died. I'm just putting it all, I'm trying to cut a long story short now. He died. And, I was absolutely traumatized. I didn't think he would just die like he was a big, strong, healthy man. And I had to stay there to get the death certificate. And the man who issued the death certificate read the doctor's report. The doctor stated a cranium accident, cranium, meaning the head. But the man said it's cardiac. And I said, no, it's cranium. He didn't understand what cranium was, and he disappeared for a few minutes. He came back, and he said his heart stopped. I said, yes, but when you die, your heart stops. He said, no, he had a car.
Louise, are you still with us? I think we've lost Louise. I think we can try and get Louise back on the line. It sounds like an awful story. I mean, the thing landed on it. It's almost like it happened later on. He wasn't getting treatment, and this condition just seems to get worse and worse and worse. She did say when she originally phoned in that she wants to talk about the fact that the death was wrongly noted by Home Affairs. Now, I'm not quite sure what impact that has on Possibly insurances. I wouldn't know what impact that.
It
Why?
would
Why?
probably only have an impact on insurance or some life policy that hasn't.
Possibly.
But I can't.
Or
see
maybe
what
as a
other-
mother, I would have possibly imagined she
Yes,
wants the
obviously,
correct cause of death actually noted on the death certificate.
But surely also the information comes from the medical practitioner that gets fed through to Home Affairs.
And as you
So-
said, none of them seem to be able to make up their mind. It's exactly what it was. That
So
one said the heart stopped,
An
the one said
action
it was a
would lie
cranial
against the
incident.
Minister of Health, I would suppose.
Is Louise back on the line with us? No, she's not. We haven't managed to get. Apparently died of a cranial problem. But while we're waiting to see if we can get Louise back on the line, we've got Maluleki in Limpopo on the line. Maluleki, good evening.
Good evening, Karen.
How are you?
Where are you?
Fine, thank you.
Thanks.
How can we help you, Maluleki?
I want to know if there is a legal way to release the person who are castrated since 2013 for a long-term hospital.
Okay, what were you put in hospital for? You've been there since 2013. What was the problem, Maluleki? Why did they put you there?
What?
What was the reason that you went to hospital in the first place? What was wrong with you?
I've got the person that a person who are being slain.
Sorry, I didn't understand what was wrong with you.
If you're slaying a person because of not having medication, is this a case from the state?
Okay, so I can't quite understand what the problem is, but he's been in hospital since 2013 and he wants to know how he can get himself released from hospital.
I was castrated since 2013.
And are you better now?
Yeah, I'm still in the hospital.
But are you still sick?
What?
Are you still sick?
I don't hear you.
Are you still not well? Is there still something wrong with you?
I'm well because since 1994 I'm a psychiatric patient. There's nothing changed in my mind. Because I have a drink and then I go to take using the medication.
Oh, this line is really, really terrible. It's breaking up all the time and we can barely hear you. I think basically if the doctors are telling you that you still need to stay there, they wouldn't keep you there because they're desperately needing beds in the hospitals as far as I'm aware these days. There's not enough space for everybody in the hospital. So if you were well enough to be released, I'm sure they would be releasing you as soon as they possibly could. But I'm so sorry, Maluleki, we really couldn't hear you very well. That line was awful. I think we have Louise back on the line. Louise, are you there?
Yes, I am.
Sorry about that. We lost you. You were telling us that
yes,
that the doctors couldn't quite make up their minds and everybody was coming up with a different cause of death.
Sorry, I couldn't hear that properly.
I said you were when we lost you, you were telling us that everybody was coming up with a different cause of death.
No, the doctor stated cranium accident as cause of
right,
death.
okay.
But the man at Home Affairs where I registered his death, that was now a few hours later. I had to do it immediately because I'm old now and I don't drive anymore. He said it's cardiac, and I said, no, it's cranium. He didn't understand the word cranium.
Okay.
And therefore, he issued the death certificate stating cause of death as natural causes. He said his heart stopped.
Okay, so now that's obviously impacted on insurance policies and things, Louise.
It will affect that as well. But the thing is, I don't think it's right. I can speak up for myself now. But what about all those many people who cannot? Somebody just says something and they walk out. I was in that position. I couldn't argue with him anymore. It was almost closing time. I was besides myself. I was in a state of shock. And there was nothing I could do. I didn't know what to do, who to talk to. And now, it's a year later. I just feel I have to do something. This has got to be put right. I want the truth. I don't want to sit with this death certificate stating a big error. No.
Well, Louise, first
What
of all,
can I do?
Louise, first of all, I'm very sorry for your loss, and let's ask the attorneys what can she do on an incorrect death certificate.
Well, of course, there are internal processes in Home Affairs, which let's be honest about it, are not always as effective, but depends which branch you go to, really. Some branches are more efficient than others. It's an unfortunate truth. But there are internal processes for correcting spelling errors on ID documents and birth certificates and these kind of things, and naturally death certificates as well. So you can either try and follow the internal process, but practically I think it will be a laborious and trying experience. If money is not really a concern, then hire an attorney and bring a court application to force them to make the change to the certificate. And that's a high court application. It may be quite costly, but it may be much more effective, and it may have a much more speedy resolution than trying to go through the internal process.
But if you do want to do the internal process, it is available, and it is something that should be open and available relatively quickly for you. But
I would recommend that you at least try the internal process. In any event, if you bring a court application, you have to prove that you've exhausted all the internal processes before you've approached court. So that, even if it's just, one process that you at least see out, that would be a good way forward, in my view.
Louise?
Yes, now this internal process, who do I contact? Where must I go?
You'll have to go back to a Home Affairs office.
The same place, the same Home Affairs.
The one that is closest to you. No, go to the one closest to you. They are all linked these days to one another.
Okay, that's great.
And then, of course, Pretoria is the hub, so the head office. So if you can go there, of course, that you go straight to the head of the beast, as they say.
Mm-hmm.
They've got all the processes, and all the senior staff and officials are situated in Pretoria. So ideally there, wonderful. But maybe a smaller office that's closest to you is even better.
Yes.
Yeah, the smaller offices always seem to work a lot faster, Louise. The smaller offices seem to work a lot faster, I think, because they don't have quite the volume that going of things.
Thank you ever so much. I appreciate this most dearly.
Well, I hope they can help you, Louise. And it's only a pleasure. I wish you much success with your efforts. I hope you can get this right. I really do.
Oh, thank you.
And I'm so sorry once again.
You are there to help people, because I knew there must be a way to solve this problem. The truth must be exposed. And as I said, I can speak up, but what about all those many other people who cannot speak up for themselves? I was in a state of shock. My son died a year ago. I couldn't face this thing. I cut myself off. I went through a severely traumatic period. I didn't want to talk about it. When anybody asked me about my son, I would say, I don't want to talk about him. I don't want to talk about it. Now I can talk. And now I'm going to do something. And a big thank you to you. I appreciate this immensely.
Louise, it's only our pleasure, and it's people like you that actually give other people hope, because they often, maybe people listening now thought there was nothing they could do, and now they've heard you, and now they realize there is something they can do too. So thank you for that. You've probably helped a lot of other people as well.
I hope so.
Thank you, Louise. Have a good evening.
Thanks, and you too.
Thank you. Good night to you. Bye-bye. Right, gosh, so we got through quite a lot to do with your favourite topic tonight, wills and things, and I knew you'll be popping in and alternating on again and with Nicoline, because she's got other things coming up that she's busy with, so she'll be coming in and you'll be alternating when she isn't available. So we'll still be doing the law clinic in the months to come, and National Wills Week, our favourite thing coming up. Yes. That's Nicoline's face just lights up when you talk about National Wills Week. So as I did last year, we'll be putting out the lists all around the country. Just let me know where you are when it's Wills Week. Don't send me any emails now, because I don't know yet which attorneys are taking part.
And we wouldn't know until
it's about a week or so before.
Yeah, July they publish the dates. Unless, of course, it's a little earlier. Sometimes it's the beginning of September. Sometimes it's beginning of October. So we'll keep you informed.
We will definitely do that. Well, my thanks once again this evening to Nicoline Skuman-Low. She's a director of Skuman Law Inc., attorneys, conveyancers and notaries public, practicing here in Cape Town, and associate attorney Anya Janssen van Rensburg, also practicing with Skuman Law Inc. And they've been my guests on tonight's edition of the Law Report program. And Nicoline or Anya will be back with us again for another law clinic on Monday, the 14th of March. Thank you both very much indeed for joining me.
Thanks for having us.
The Law Report, as you all know by now, is on the air on SAFM every Monday evening between 9 and 10. And in next week's program, I'll be joined in studio by immigration attorney Chris Waters. So if you've got any questions on that, join me for that. That's the Law Report next Monday, the 15th of February. And I'll be back with you again tomorrow evening just after 9 with Health Matters. And it's our monthly phone-in. And this month we'll be talking about ADHD, that's Attention Deficit Hyperactivity Disorder, and how it affects both children and adults. Well, Stephen Kirk is